In this lecture, we shall discuss the law of contracts. Specifically, we shall introduce the discussion on what amounts to an offer in law. In this lecture, we shall seek to explain what qualifies as an offer in law and how an offer can be distinguished from an invitation to treat. We shall seek to explain what an offer is and then see how we can distinguish an offer from an invitation to treat. Now, this topic is very important because in the law of contracts, there are some key elements that have to be established before we can conclude safely that there is a valid contract in existence. And one of the key elements is that there must be an offer and a corresponding acceptance. Now, the other elements like that there must be an intention to create legal relations and that there must be consideration and also that the parties must have the requisite capacity to contract. But in all these things, you realize that there's always a requirement that before there can be a valid contract, then there must be an offer which is going to be met with a corresponding acceptance. So the question then is, how do we conclude and identify that there is a valid offer in existence? Like I've said, the existence of a valid offer and a corresponding acceptance is a requirement for a valid contract to be found to be in existence. In some textbooks, you will see that element being described as that there must be an agreement. So the first element of a valid and a binding contract that we are discussing is that there must be an offer and a corresponding acceptance. So what then is an offer? In this lecture, we shall explain what an offer is. We shall distinguish an offer from an invitation to treat. And we shall look at the different forms of invitation to treat that we can have in the law of contract. So the first thing is to explain what an offer is. To explain what an offer is. Now, there's this Ghanaian case of NTHC versus Entry. And this Ghanaian case of NTHC versus Entry is very, very helpful in determining what amounts to an offer. Now, the Supreme Court of Ghana, in this case of NTHC versus Entry, the Supreme Court of Ghana, speaking through Dati GS, gave some elaborate explanation of what amounts to an offer. And this is what the learned author says, and I quote, basically, an offer is an indication in words or by conduct by an offeror that he or she is prepared to be bound by a contract in the terms expressed in the offer if the offeree communicates his acceptance. If the offeree communicates to the offeror his or her acceptance of those terms. Accordingly, the offer has to be definite and final and must not leave significant terms open for further negotiation. By significant, we here mean terms that are essential to the bargain contemplated. It is important to emphasize the proposition that the mere acceptance of an offer is sufficient to turn the offer into a contract if there is consideration for it, together with an intention to create legal relations, and the quote ends. Now, from the dictum of Datiban JSC, in the case of NTHC versus entry, what can we glean to be the definition of an offer? And it's important at this point to rehash the words of Datiban JSC in NTHC versus entry. He says, and I quote once again, basically, an offer is an indication in words or by conduct by an offeror that he or she is prepared to be bound by a contract in the terms expressed in the offer if the offeree communicates to the offeror his or her acceptance of those terms. Now, from this, what we can glean is that an offer can first be made either in words or it can be made by conduct. Now, the essential thing to note about this definition is that the learned justice emphasizes that an offer must have that characteristic that the moment the person to whom the offer is made communicates his acceptance, then the offer is going to be converted into a contract. If whatever has been communicated does not have this essential characteristic, then it will not qualify to be an offer. That words or the conduct, it must have that finality such that the moment the person to whom it is made communicates his acceptance, then we are going to have a contract if there is consideration and there's an intention to create legal relations. So if the words that are communicated do not have that finality attached to them, they do not have that capability of being converted into a contract the moment the person to whom it is made communicates acceptance. If there's no finality like that, then the words cannot amount to an offer. And so you will see that in this case of NTHC versus entry, the learned justice Datiban indicates that accordingly, and I'm quoting, accordingly, the offer has to be definite and final and must not leave significant terms open for further negotiation. What does it mean by this? It means that the offer must be definite and it must be final. That I hereby offer my car to you for sale at 5,000 Ghana cedis. If you want to buy it, communicate your acceptance not later than 3 p.m. on 1st of January. This one, it is clear. There's nothing less for further negotiation. The price is there, how you can communicate your acceptance is there. So an offer must be definite, it must be final, and it must leave nothing further for negotiation. And it must have that capability of being converted into a contract the moment the person to whom it is made communicates his acceptance. And so from the dictum of Datiban JSC, there should be some points that we can glean from what to make some words or conduct amount to an offer. Now, we can now at this point conclude that an offer can be made to an individual or that an offer can also be made to a group of individuals, or that an offer can also be made to the world at large. Now, we can also note that before some statement will amount to an offer, then the statement must demonstrate willingness on the part of the person making the statement to enter a bargain. And also, the person making and expressing the willingness must also demonstrate what he requires the person to whom the offer is made to do by way of acceptance. So, as for an offer, they are saying that there must always be that finality attached to it. In fact, if you leave something further for negotiation, then it cannot qualify to be an offer. And you can see that I'm emphasizing on this point because it is this finality which is attached to the offer that is what distinguishes an offer from an invitation to treat. And that is why I have spent the first few minutes so much time to rehash the point that before some words would amount to an offer, they must be definite, they must be final, and they must leave nothing further for negotiation. And they must have that capability of immediately being converted into a contract the moment the offeree or the person to whom the offer is made communicates his acceptance. And this point that I just made has been emphasized again by the Tebaan JSC of the Supreme Court of Ghana in the same case of NTAC versus Entry. And in order to drum home the point strongly, permit me at this point to once again read from NTAC versus Entry so that we can tell how the Tebaan JSC distinguished an offer from an invitation to treat. This is what the learned justice says, and I quote once again. It is this need for finality and definiteness which leads to the analytical need for the concept of invitation to treat. If a communication during negotiations is not the final expression of the alleged offeror's willingness to be bound, it may be interpreted as an invitation to the other party to use it as a basis for formulating a proposal emanating from him or her that is definite enough to qualify as an offer. Thus, the indefinite communication may be what generates an offer from the other side. End of quote. Now, what the learned justice is saying in the Ghanaian case of NTAC versus Entry is that when the communication is so indefinite, then it may well be that that indefinite communication, which is not final, which is not definite, it may well be that that communication is what is rather inviting the other party to make an offer. So, for example, if the person makes a statement which is so indefinite, is not final, then it may rather be inviting the person to whom it is made to rather make an offer. For example, the person makes a statement saying that, well, it may be good to sell this vehicle. Now you can tell that from this statement, there's nothing said about price. There's nothing said about how you should even communicate your acceptance. There's nothing said about when acceptance should be communicated. So if I say, it may be good to sell this vehicle, I may be inviting the people around to rather make an offer. In other words, because the statement I made is not definite, because the statement I made is not final, because the statement I made leaves a lot of things for negotiation, that statement cannot, by any stretch of legal imagination, amount to an offer. Because there are a lot of things that have been left for discussion. I just said it may be nice to sell this vehicle. Nothing said about price. So this statement cannot amount to an offer. That is why the learned justice that the Tebaan JSC says that it is this need for finality and definiteness which leads to the analytical need for the concept of invitation to treat. And he says that if a communication during negotiations is not the final expression of an alleged offeror's willingness to be bound, it may be interpreted as an invitation to the other party to use it as a basis for formulating a proposal emanating from him or her that is definite enough to qualify as an offer. Thus, the indefinite communication may be what generates an offer from the other side. And in fact, the learned justice goes ahead to say that an invitation to treat, I'm still quoting the Tebaan JSC in the case of NTAC versus Entry of the Supreme Court of Ghana. The learned justice says as follows, and I quote, an invitation to treat is thus to be distinguished from an offer on the basis of the proposal's lack of an essential characteristic of an offer, namely its finality which gives a capacity to the offeree to transform the offer into a contract by the mere communication of his or her assent to its terms. End of quote. So take note of this statement because it will be very helpful to you when we get to the different forms of invitation to treat. Remember this statement, that an invitation to treat is thus to be distinguished from an offer on the basis of the proposal's lack of an essential characteristic of an offer, namely its finality, which gives a capacity to the offeree to transform the offer into a contract by the mere communication of his or her term assent to its terms. So when we get to invitation to treat and we are looking at the different types, you realize that the different kinds of invitation to treat that we will look at, for those ones, they are rather inviting the other party to make an offer. In other words, when the other party communicates any words, those words the other party communicates cannot amount to an acceptance because it's that other party who is rather being invited to make the offer. In fact, there is one statement that brings out the distinction between offer and acceptance, offer and invitation to treat clearly. And it is so important that I have to make reference to this statement. And you will get the statement from Chitty on Contracts. And I refer you to the 28th edition, volume 1, paragraph 2, at page 93. In fact, when you get there, you will see the important statement that has been made to distinguish an offer from an invitation to treat. Now, if you look at this particular author and the statement that he makes in relation to invitation to treat, this is what the learned author says, and I quote, "A communication by which a party is invited to make an offer is commonly called an invitation to treat. It is distinguishable from an offer primarily on the ground that it is not made with an intention that it is to become binding as soon as the person to whom it is addressed simply communicates his assent to its terms." End of quote. Now, take note of this quote carefully. The learned authors are telling you that a communication by which a party is invited to make an offer is commonly called an invitation to treat. And the learned authors say that it is distinguishable from an offer primarily on the ground that it is not made with the intention that it is to become binding as soon as the person to whom it is addressed simply communicates his assent to its terms. And so, simplistic though the distinction between an offer and an acceptance looks, as we proceed, you will see that there have been several cases that have mainly turned. In fact, the fate of the parties have wholly depended on whether the words communicated amounts to an offer or not. And I'll introduce you to two key cases. The moment you get these cases, your understanding of offer and invitation to treat will be complete. There are two cases that involve the same defendants. They are the cases of Gibson versus Manchester City Council and also Storer versus Manchester City Council. The moment you get these two cases, your understanding of offer and acceptance, offer and invitation to treat will be complete. And you will not have any problem again in your ability to distinguish an offer from an invitation to treat. So we shall begin with the first case of Gibson versus Manchester City Council. Gibson versus Manchester City Council is reported in the 1979 Weekly Law Report at page 294. Gibson versus Manchester City Council, reported in the first volume of the Weekly Law Reports at page 294. And the facts and holding that I shall proceed to give in this case of Gibson and Manchester City Council, the facts I shall give and read out are facts and holdings taken from Gio-Poole's book on contract, Gio-Poole's case book on contract law. Now, these are the facts that we can get from Gio-Poole's case book on contract law. And I read, and these are the brief facts of Gibson versus Manchester City Council. And I read, the council adopted a policy of selling houses to tenants. The respondent tenant applied on a printed form for details of the price and mortgage terms. The city treasurer wrote to the respondent that the council may be prepared to sell the house to you at the purchase price of £2,725 sterling, less 20%, which would equal £2,180 sterling. The letter gave details of the mortgage likely to be made available and stated, and I quote, if you would like to make a formal application to buy, please complete the enclosed application form and return it to me as soon as possible. End of quote. Owing to the crucial importance of this quote, which was in the letter, I shall read it once again. The city treasurer wrote to the respondent, and the letter gave details of the mortgage likely to be made available and stated, if you would like to make a formal application to buy, please complete the enclosed application form and return it to me as soon as possible. The respondent completed the application form and returned it. Before contracts were prepared and exchanged, political control of the council changed, and the council decided to proceed only with those sales for which contracts had already been exchanged. I'll take that portion again. The respondent completed the application form and returned it. Before contracts were prepared and exchanged, political control of the council changed, and the council decided to proceed only with those sales for which contracts had already been exchanged. The respondent sought specific performance of an alleged contract to purchase his council house, claiming that he had accepted the offer in the city treasurer's letter. Now, at this point, let me go over this case and then highlight exactly what is happening. Now, there is a council, which is the Manchester City Council. They adopted a policy of selling their houses to their tenants. Now, the respondent in this case applied for the price and mortgage terms. The treasurer wrote back, and the content of the letter is very important. The content of the letter that the city treasurer wrote to the respondent reads, it said, they may, the operative word is may, they may be prepared to sell the house to you at the purchase price of, and the price is quoted. Operative word there, they may be prepared. And what is even more crucial, the letter went ahead to state that if you would like to make a formal application, complete the enclosed application form and return it to me as soon as possible. So the city treasurer is actually inviting the respondent to make a formal application by completing the enclosed application form and returning it. Now, even though the respondent completed the application form and returned it, no contracts were prepared, no contracts were signed. Now, when the government changed hands and there was a new party in power, they decided to only sell the house to people that they already had an existing contract with. So the question then will be, what had transpired between the city council and Gibson? That is, Gibson filling the application form and returning it. Whether that process would create an existing contract, because if it is found that the filling of the application form would amount to an acceptance, then it means that there would be deemed to be a valid contract. But if it is found that the statement and the filling of the forms by Gibson actually amounted to the offer, then it means that then there will be no contract, because as we have seen, when Gibson filled the application form and sent it, there was no response from the city council, there was no contract that was signed. So what then would be the holding of the court? Now, if you look at the holding of the courts, remember the main issue would be that the letters that were sent by the city council to Gibson, would they be deemed to be an offer? If they would be deemed to be an offer, then it means that the communication Gibson made by filling the application form and sending it, it will be deemed to be an acceptance. But if the communication from the council is construed to be an invitation to treat, then what it would mean is that it is Gibson that has rather made the offer, which may or may not be accepted by the city council. So we must determine the legal status of the communication made by the Manchester City Council. We must interrogate that communication and find out whether the communication would amount to an offer or whether it would amount to an invitation to treat. And like I've said, if we establish that the communication by the council amounts to an invitation to treat, then what it means is that Gibson will be deemed to be the one who made the offer, which the council has not yet accepted. Remember, the new political party is saying that only sell the house to people that you have an existing contract with. Now, this is the holding of the courts. And this holding we can glean from the Jill Poole's casebook on contract law, 13th edition, and I quote, "There was no binding contract because no offer capable of acceptance had been made by the council. The statements in the city treasurer's letter that the council may be prepared to sell." Again, the statement in the city treasurer's letter that the council may be prepared to sell and inviting Mr. Gibson to make a formal application to buy did not constitute an offer to sell, but was only an invitation to treat. Now, these are the words of one of the justices, Lord Russell, and these are his words at page 980 of the report. Now, Lord Russell said as follows, and I quote, "My lords, I cannot bring myself to accept that a letter which says that the possible vendor, quote, may be prepared to sell the house to you, can be regarded as an offer to sell, capable of acceptance so as to constitute a contract. The language simply does not permit such a construction. These are the words of the justice in the case of Gibson and Manchester City Council. So what we have gotten so far in this case of Gibson and Manchester City Council is that the council wanted to sell houses to their tenants. Then they wrote to the respondent that the council may be prepared to sell to you. The letter gave details of the mortgage likely to be made available, and instead, if you would like to make a formal application, complete the form and return it. What we have seen at this point is that the court has construed the letter sent by the council as an invitation to treat. Meaning that when Gibson filled the application form and sent it, he rather made the offer. And that offer was not accepted before the government changed hands. So since it wasn't accepted, it means that there was no contract with Gibson. And therefore, they were not bound to sell the house to Gibson. And that's why I will once again read the whole name of the court as we can capture from Jill Poole's casebook on contract. And this is what it says, that there was no binding contract because no offer capable of acceptance had been made by the council. The statement in the city treasurer's letter that the council may be prepared to sell and inviting Mr. Gibson to make a formal application to buy did not constitute an offer, but was only an invitation to treat. So at least we can conclude on this Gibson case that it was the council who made the invitation to treat, Gibson made the offer, and there was no acceptance before there was a change in government. Since there was no acceptance, then there was no contract. Now, like I said, this case of Gibson and Manchester City Council has to be contrasted with the case of Torah versus Manchester City Council, also reported in 1974, 3 All England reports at page 824. Now, this case of Torah versus Manchester City Council, reported in 1974, 3 All England reports at page 824. These are the facts and holding that we can get from the head notes. And like I said, the moment you can distinguish this case from Gibson, you are 100% well vexed in issues related to offer and acceptance and invitation to treat. So Torah versus Manchester City Council, reported in 1974, 3 All England reports at page 84. These are the facts and holdings that we can get from the head notes of the case. And I read as follows, and I quote. In 1970, a corporation then under the Conservative Party control resolved to offer council houses for sale on favorable terms to certain tenants. The town clerk was instructed to prepare a simple form of agreement for sale. The form prepared accorded with the instructions, giving spaces for details of purchaser's name, the property, the price, the mortgage amount, if any, the proposed purchaser solicitors, and by clause 7, the date when your tenancy ceases and mortgage repayment will commence. It stated that there would be no investigation of title and that the conveyance would include a restriction against lease or sale of the property for 5 years. In February 1971, the plaintiff, Storer, applied on the corporation's application form, stating that he wished to purchase his house with the benefit of a mortgage. On March 9th, the city treasurer replied that the corporation would lend Stora the whole purchase price, repayable over 25 years. On the same date, the town clerk wrote a letter enclosing the agreement for sale and a list of solicitors and stating, if you will sign the agreement and return it to me, I will send you the agreement signed on behalf of the corporation in exchange. Again, if you will sign the agreement and return it to me, I will send you the agreement signed on behalf of the corporation in exchange. Most of the details on the form had been filled in, but the date under clause 7 was not put in. The letter invited Stora to select a solicitor from the list to advise him on the purchase. He put in solicitors' names, signed it, and returned it to the town clerk on March 20th. The date under clause 7 was still left blank, but an internal memorandum dated March 12th from the tenancy's manager to the town clerk recommended March 22nd or April 12th as alternative dates for completion of the sale. The local authority did not find time to complete and send to Stora the corporation's agreement in exchange at that time. And in May, local elections were held, which put a Labour Party majority in control. The policy of selling houses was reversed, and the town clerk was instructed to write to those tenants, including Stora, who had sent in their agreements for sale, telling them that the council had decided to proceed with sales only in those cases where contracts had been exchanged, and that as there had been no formal exchange in the case of Stora, the proposed sale could not proceed. In a county court, Stora asked for an order of specific performance of the contract. By their defense, the corporation claimed that there was no concluded contract, and further that as the date in clause 7 was a material term and was not filled in, any alleged contract was void for uncertainty. Now, let us digest what is going on so far. Now, in this case, you have to pay critical attention to the letters written in the forms that were filled. Now, take a critical look at the facts. Now, the town clerk was instructed to prepare a simple form of agreement for sale. This form gave space for details of purchaser's name, the property, price, mortgage amounts. Great. Now, the city treasurer wrote a letter saying that if you will sign the agreement and return it to me, I will send you the I will send you the agreement signed on behalf of the corporation in exchange. That statement is very crucial. If you will sign the agreement and return it to me, I will send you the agreement signed on behalf of the corporation in exchange. Very definite communication. Now, if you will sign this agreement and return it to me, I will also send you the agreement signed on behalf of the corporation. No doubt, very definite statements. And more importantly, most of the details on the form had been filled in. The only thing left out was the date. And when we say most of the things in the form have been filled in, remember the things that It means that purchaser's name is over there, price is over there, mortgage amount. The only thing left was when the agreement to be deemed to commence, the date. Now, the council is saying that all that they sent out was an invitation to treat. And therefore, what Stora did was rather make an offer, which they are not yet accepted. Stora is saying that no, what they said to him, that if you will sign this and return it, that statement means that they had made a definite offer. And that as soon as he saw Stora feels it and sends it back, they are bound to accept it. So Stora is saying that the communication that came from the council amounted to an offer, which he has accepted by filling the form and sending it. So there's a contract, according to Stora. So Stora has sued them asking for an order of specific performance. But the council is also saying that the letter they sent amounted to an invitation to treat. And that if anybody at all made an offer, then it was rather Stora. What did the court hold? Now, the court held that the statement and the letters written by the council actually amounted to an offer. And that Stora filling the form and returning it amounted to an acceptance. Because, as we will soon see, the communication by the council was definite, it was clear, it left nothing further for negotiation. The most important terms of the agreement, the price, they had all been agreed on. What was only left outstanding was the date on which we had to insert. Apart from that, the relevant things have been inserted. So that's the holding that we can get from the head notes, and I read. In the context of a scheme designed to dispense with legal formalities, of which the formal exchange of contracts was one, there was, on the documents concluded, agreement for the sale and purchase of the house from the moment when the tenant accepted the terms of the offer by completing and returning the agreement for sale. And he was entitled to specific performance of that contract by having the property conveyed to him. The addition of the date under clause 7 was a mere matter of administrative convenience, an arrangement between the parties, and its absence on March 20th did not affect the validity of the contract. So what you can get so far from this case is that the court is holding that the communication made by the council amounted to an offer. And this offer was accepted by Stora when he filled the application forms and sent it. In fact, what is even more important and even makes everything clear about this Stora and Manchester City Council are the words of Lord Denning and how he dissected the law in relation to offer and invitation to treat. In fact, owing to its crucial importance, I will even go ahead and read the dictum of Lord Denning to demonstrate how he explained that the communication from the council actually amounted to an offer and not an invitation to treat. Now, these are the words of Lord Denning in the case of Stora versus Manchester City Council, and I quote, in May of 1971, there was a change in the control of the Manchester Corporation. Previously, the Conservatives had been in control. Afterwards, it was Labour. The change had legal repercussions. During the Conservative administration, the policy of the corporation was to sell their houses to tenants on favorable terms. They were willing to sell to any certain tenants who had been in occupation more than a year. The sale price was to be the market value of the house it sold with vacant possession, but with a reduction of the tenant according to the length of time he had been in the premises as a tenant. He might get a reduction of from 10 to 20% on the price. Furthermore, the corporation were ready to give him 100% mortgage. When the Labour administration took over in May 1971, that policy was reversed. The Labour-controlled administration decided that they would not sell council houses to tenants. But they realized that they could not go back on existing contracts. So they gave instructions to the officers that they were to fulfill existing contracts, but not to make fresh contracts. Now, in many cases, tenants had filled in various forms applying to buy their houses, but the contracts of sale had not been exchanged. The tenants claim that firm contracts had been made even though the contract had not been exchanged. But the town clerk thought that the contracts were only binding when contracts of sale had been exchanged. So he wrote this letter to the tenants, and I quote, "At their meeting on July 7, 1971, the council decided to discontinue the scheme for the sale of council houses and to proceed only with those cases where contracts had been exchanged. As contracts have not been formally exchanged in this case, I am unable to proceed with the proposed sale." End of quote. Lord Denning went ahead to deliver himself as follows, and I quote. And remember, we are still on the case of Storer versus Manchester City Council, and Lord Denning continues as follows. "Now, Mr. Storer, one of the tenants, has brought this action to test that ruling. The facts are these. Mr. Storer was a tenant of a council house, 167 Moorcroft Road, on November 15, 1970. He filled in a request for information, asking for the price and details of any mortgage. On January 14, 1971, the corporation wrote saying that they may be prepared to sell the house to you at the price of £2,750, less a discount of 17%, as he had had a council house for several years, making a net sum of £2,282. If he were granted a mortgage, it would be for $2,279, repayable over 25 years. They said in their letter, and I quote, "This letter should not be regarded as a firm offer of a mortgage." End of quote. Lord Denning went ahead to say as follows. Later on, however, they did make a firm offer, as I will show. On February 11th, 1971, Mr. Storer filled in an application form to buy a council house. He said, and I quote, "I wish to purchase my council house." End of quote. In it, he asked for a loan on mortgage. On March 9, 1971, the city treasurer wrote to him, and I quote, "The corporation will lend £2,279 sterling, repayable over 25 years with interest at 8.5%. The total monthly installment payable would be £1,498 sterling." On the same day of March 9, 1971, the town clerk himself wrote a letter which is of crucial importance in this case. And I quote the content of the letter. "Dear Sir, sale of council house. I understand you wish to purchase your council house and enclose the agreement for sale. If you will sign the agreement and return it to me, I will send you the agreement signed on behalf of the corporation in exchange." And I have to quote this letter again from the council. "Dear Sir, sale of council house. I understand you wish to purchase your council house and enclose the agreement for sale. If you will sign the agreement and return it to me, I will send you the agreement signed on behalf of the corporation in exchange. From the enclosed list of solicitors who are prepared to ask for you and advise you on the purchase, please let me know the name of the firm that you select as soon as possible." End of quote of the letter. Lord Denning proceeded as follows. Enclosed with that letter was a form headed City of Manchester Agreement for Sale of Council House. The corporation had filled in various details, such as the name of the purchaser, the address of the property, the price, the mortgage amount, and the monthly repayments. Please take note of this very well, because this is what draws the line between Storer and Manchester City Council and Gibson and Manchester City Council. In Gibson, the plaintiff only filled the form and returned it. There was no response from the council. Over here, when Storer applied, the council has responded. And we are being told by Lord Denning that when they responded, the council mentioned that if you will sign the agreement and return it to me, I will send you the agreement signed on behalf of the corporation in exchange. So at this point, we see one difference between Storer and Gibson. In Gibson, as soon as the application was made, there was no communication from the corporation and government changed hands. In this case, after the application was made, there is a response which says that if you will sign the agreement and return it to me, I will send you the agreement signed on behalf of the corporation in exchange. Not only that, when the corporation were also writing to Storer, they filled in various details, such as name of purchaser, address of the property, the price, the mortgage amount, and monthly repayments. There was this item left blank. Date when your tenancy ceases and mortgage repayments will commence, followed by these clauses. Mr. Storer filled in that form, filled in the name of the solicitors. He signed the form himself and returned it on March 20th, 1971. So he had done everything which he had to do to bind himself to purchase the property. And I'm quoting from Lord Denning. Lord Denning says, Mr. Storer filled that form. He filled in the name of the solicitors. He signed the form himself and returned it on March 20th, 1971. So he had done everything which he had to do to bind himself to purchase the property. The only thing left blank was the date when the tenancy ceased. The sale would have gone through, no doubt, within a short time, but for the corporation and the town clerk's office being so pressed. The housing manager passed a note to the town clerk suggesting that the sale be completed with effect from Monday 22nd or Monday April 12th. But nothing more was done before the election, which brought the change of control in the corporation. The town clerk staff were apparently overworked and did not deal with the matter in time. Then in May 1971, there was the election. In July 1971, the corporation, under the new control, resolved that there were to be no more sales to council tenants. But the corporation recognized that they had to go on with cases where the corporation were legally bound. Thereupon, the clerk wrote to Mr. Storer, another tenant in like situation, in a letter stating, as contracts have not been formally exchanged in this case, I am unable to proceed with the proposed sale. The tenant took the advice of the lawyers of Hargreaves and Co. Some 120 other tenants also took advice. They were advised that there was a binding contract, even though formal contracts had not been exchanged. So this case of Mr. Storer has come as a test for Manchester Corporation. It is to decide whether or not exchange is necessary in order to form a concluded contract. Where parties are arranged for a sale subject to contract, that means, as a rule, that there is no binding contract until the contracts of sale have been formally exchanged. But where there is no agreement subject to contract, the only question is whether a contract has been concluded. The corporation put forward to the tenant a simple form of agreement. The very object was to dispense with legal formalities. One of the formalities, exchange of contracts, was quite unnecessary. The contract was concluded by offer and acceptance. The offer was contained in a letter of March 9, in which the town clerk said, and I quote, I enclose the agreement for sale. If you will sign the agreement and return it to me, I will send you the agreement signed on behalf of the corporation in exchange. The acceptance was made when Mr. Storer did sign it, as he did, and return it, as he did on March 20th. It was then that a contract was concluded. The town clerk was then bound to send back the agreement signed on behalf of the corporation. The agreement was concluded on Mr. Storer's acceptance. It was not dependent on the subsequent exchange. I appreciate that there was one space in the form which was left blank. It was number 7 for the date when your tenancy ceases. That blank did not mean there was no concluded contract. It was left blank simply for administrative convenience. So here, the filling in of that date was just a matter of administrative tidying up to be filled in by the town clerk with a suitable date for the changeover, the date on which Mr. Storer ceased to be a tenant and become a purchaser. A further point was taken. It was said that the town clerk had not actually signed the form of agreement. No matter. He had signed a letter of March 9, 1971, and that was sufficient. It was a note or memorandum sufficient to satisfy the statutes. The final point was this. Mr. Francis said that the town clerk did not intend to be bound by the letter of March 9, 1971. He intended that the corporation should not be bound except on exchange. There's nothing in this point. In contract, you do not look into the actual intent in a man's mind. You look at what he said and did. A contract is formed when there is, to all outward appearances, a contract. And man cannot get out of a contract by saying, I do not intend to contract, if by his words he has done so. His intention is to be found only in the outward experience, which his letters convey. If they show a concluded contract, that is enough. It seems to me that the judge was quite right in holding that there was a binding contract in this case, even though there was no exchange. It is a proper case for specific performance, and I would dismiss the appeal. End of quote of Lord Denning in the case of Stora versus Manchester City Council. Now, at this point, it is possible for us at this point to now draw the distinction between the case of Gibson versus Manchester City Council and Stora versus Manchester City Council. In Gibson, the letter from the council stated that they may be prepared to sell at stated prices. And the letter even stated that if you would like to make a formal application to buy, please complete the enclosed application form and return it to me as possible. So in Gibson, the council was inviting the tenant to make the offer. And when the tenant completed the offer and returned it, there was no communication about price, there was no communication about date, nothing. And then there was political change of governance. That is why in Gibson, we feel that there were some more important terms that were left for negotiation. More important terms like the price and things like that. So in that instance, the communication by the council would amount to an invitation to treat, because there were a lot of terms left for negotiation. And the application form filled by Gibson would amount to the offer, which was not accepted before the change of government. But in Stora, prices had been filled in by the council. The only thing that was left was for dates on when it was supposed to commence, when it will cease to be a tenant, and when the purchase will begin. It means that all important terms have been filled in. There was nothing important left for negotiation. So, Lord only mentioned that the corporation had filled in various details, such as name of purchaser, address of property, the price, mortgage, amount, and the monthly repayment. So in that instance, it is very clear what the distinction is. And so in Stora, there was nothing important left for negotiation. That is why the court concluded that there have been a valid contract. And therefore, the council had to go ahead and sell the house to the tenants. So these two places draw the distinction between an offer and an invitation to treat. It is important at this point to rehash the words of Dr. Ban JSC in NT Aces versus Entry, where the learned justice explained what will amount to an offer. That it is an indication in words or by conduct that an offeror would be bound the moment the offeree communicates his acceptance. Dr. Ban went ahead to mention that accordingly, the offer has to be definite and final, and must not leave significant terms open for further negotiation. By significant here, we mean terms that are essential to the bargain contemplated. So if you look at that Ban statement in context, And you even apply it to the Gibson case. You can see that in the Gibson case, because further terms were left for negotiation like price, then there can be no contract. But in the Stora case, because nothing was left further for negotiation, all material things have been concluded. Name of purchaser, price, everything has been concluded. That is why the courts found it very easy to hold that there was a valid contract. So by way of recap in this lecture, we know what the definition of an offer is. According to Dateba in NT 80 versus NG, that it is an indication in words or by conduct by an offeror that he or she is prepared to be bound by the contract in the terms expressed in the offer if the offeree communicates to the offeror his or her acceptance to those terms. And we have been told that the main thing that distinguishes an offer from an invitation to treat is that the invitation to treat lacks that finality which gives the other party to whom it is made to convert it into a contract. Remember, we mentioned that as for an invitation to treat, it is the one that will rather invite the other party to make the offer. And on this point, we refer to treaty on contracts, where it mentions that a communication by which a party is invited to make an offer is commonly called an invitation to treat. So the letter sent by the Manchester City Council to Gibson, that letter was inviting Gibson that if you wish to make a formal application, fill this form and bring it. So that letter that was coming from the Manchester City Corporation, it amounted to an invitation to treat. And that is why the form that was filled by Gibson amounted to the offer, which was not accepted by the council. So remember treaty on contracts, that a communication by which a party is invited to make an offer is called an invitation to treat. And then now you can apply this to the case of Gibson and also the case of Stora and understand why in that case the court construed the letters from the council to amount to an invitation to treat in that particular context. So remember the case of NT 80 versus entry, that the ban GSC in its definition of an offer. Remember the case of Gibson and Manchester City Council on how the court construed the letters from the council to be an invitation to treat, and juxtapose that to the case of Stora versus Manchester City Council and see why in that case too, the court concluded that there have been invalid contracts. And remember what we said in treaty on contracts, that a communication by which a party is invited to make an offer is called an invitation to treat. Having explained what an offer is and having distinguished it from an invitation to treat, our next lecture shall be identifying and explain the different forms that we can have invitation to treat. There are different forms of invitation to treat. So for the different forms of invitation to treat, we'll be looking at things like display of goods as invitation to treat. That's when you display goods for sale, they do not amount to an offer, but they're rather inviting people to make an offer. We'll look at auction sales, that they are not offers, but they're rather invitation to treat. We'll look at tenders. We shall also look at advertisement of goods in the newspaper. We shall also look at circulation of price lists or catalogs. These are different forms of the invitation to treat. But for purpose of this lecture, we have sought to equip you with the legal knowledge so that you can distinguish an offer from an invitation to treat. So from here, whenever you see an offer, you know that the man said, it must leave nothing further for negotiation. It must be definite. It must be final. It must have the capability of being converted into a contract the moment the other party communicates acceptance. Now that you know this one, you know what invitation to treat is. Our next lecture, we shall go and look at the different categories of invitation to treat. So this is where we shall wrap up with our discussion on offer and how an offer can be distinguished from an invitation to treat. Always remember the definition by Dateba JSC in NT80 versus entry, and remember what treaty on contracts who said about invitation to treat And remember, the two cases with the same defendant, Gibson and Manchester City Council, and Stora versus Manchester City Council. In our next lecture, we shall go ahead and look at the different forms of invitation to treat. This is where we shall wrap up on this particular lecture. Thank you.